Good afternoon, everybody. Thank you for joining us today for this seminar. And it's titled Intellectual Property for Business Lawyers. It's really designed for anybody who is not an intellectual property lawyer. So thank you for joining us. I am the president of the Seminole County Bar Association. I would like to give you some announcements of some future events that we have planned, but we have a lot of really important content today. So I'm going to ask you instead to just look at our website and look out for our emails for future CLE events. Before we get started, I do need to thank two very important people, Eric Bowman and Tony Peasy with his firm, who have been really extraordinarily helpful and assisting us with this CLE program today. And we thank them and their firm, Forster Bowman, for providing the platform. So let me move on to the introductions. We are so privileged today to have three really extraordinary attorneys with us on this panel. They are all three with the law firm of Allen Dyer Doppelt and Gilchrist, PA. You're probably familiar with their Orlando office, but they actually have offices throughout Florida. We have three attorneys with us today. Ava Doppelt is our first panelist. And as far as I'm concerned, Ava is a living legend for us. And particularly in the Central Florida legal community among female attorneys. And so the rest of this sounds very technical to me, but I'm going to tell you a little bit more about her background. But if you're a female attorney practicing law and anywhere, you need to thank Ava at some point when you can. She's been more of a trailblazer than anybody I can think of right now. So thank you on behalf of all of us. Ava is a shareholder, and she practices primarily in the areas of copyright and trademark law. She graduated Phi Beta Kappa from Northwestern University and then received her law degree from New York University. Interestingly, before she moved to Florida, she was actually working for the Reader's Digest company. And if you'll recall, that was a very popular publication and still is, I believe. Ava has served on multiple committees in the intellectual property, franchising, antitrust, and entertainment law arena with the American Bar Association, but also both the Florida and New York Bar Associations. She is a member of the New York Bar as well. She has also been a member of the Trademark and Unfair Competition Committee of the Association of the Bar of the City of New York. And she has also led us as the president of the Florida Association of Women Lawyers, as well as our Central Florida chapter. She's also chaired the Ninth Circuit Judicial Nominating Commission and the Florida Bar Ninth Circuit Grievance Committee. She has lectured and served as an expert witness extensively in the area of intellectual property, but also related areas, copyright, trade secret, franchise, publishing, entertainment, and internet law. She's also, and I guess in her spare time, been an adjunct professor of trademark law at Barry University School of Law, and she's also lectured at the University of Florida Levin College of Law. She's also been on the board of directors and is still serving on the board of directors for the Florida Lawyers Mutual Insurance Company, the Citrus Club, and the Association to Preserve the Eatonville Community. And she is also on the Dean's Advisory Council of Florida A&M College of Law. Jack Abid is one of our other panelists today. He is also a shareholder and a registered patent attorney at the firm. Jack actually gave me, I guess, what I would consider a truncated introduction for him that really just highlights his professional achievements. I want to also add that he has significant academic achievements as well, and you can find those on his profile on their website. But he specializes in patent prosecution and intellectual property portfolio management. He also attended the University of Florida Levin College of Law and received his bachelor degrees from both the Georgia Institute of Technology and Jacksonville University. He, in 15 years of the practice of law, has prosecuted nearly 900 patents and approximately 800 have resulted in issued patents, which is pretty extraordinary. I want to also add that Jack is a member of the Seminole County Bar Association, and every time I see him, he has a smile on his face, and so I appreciate that. Matthew McKinney is our third panelist today. Matt is also a shareholder and registered patent attorney with the firm, and he also practices in the areas of intellectual property, and he represents a wide range of clients in connection with the acquisition, transfer, enforcement, and defense of their intellectual property rights. Matt has an extensive engineering and physics background and is very experienced in prosecuting mechanical, communications, computer hardware, software, and electronics patent applications. He also has extensive experience in litigating these matters. So thank you all. And without further ado, I want to turn it over to Ava to get our presentation started. I will announce the CLE number at the end, and we will post it in the chat. And you'll also receive an email later if you miss it during the presentation. Thank you.
Does this mean
You're speaking.
okay? Hello, thank you. Can everybody hear me? I hope that means that I'm on.
Yes.
I'm Ava Doppelt, and we are very happy and honored to be presenting today to the Seminole County Bar Association. I was going to introduce my colleagues, but I don't have to because Sherry did such a great job. And for me, it just sounds like I've been around for 100 years. I do want to thank Sherry and Eric and Tony for putting this all together. It was great, and they were wonderful. Just so you know, our firm, as Sherry told you, is an intellectual property firm, but your own bar leadership and thought, and we agree, that it's important to know something about IP, even if you're not an IP lawyer, so you can help your clients develop their important assets. And sometimes these are the most important assets of their business. I mean, think software companies, tech businesses, entertainment businesses, architects, gaming companies. You know, the primary asset these people have is their intellectual property. So even if you're not an intellectual property lawyer, you need to recognize IP issues when, or, you know, helpfully before they arise, and avoid giving out misinformation or bad advice. This, of course, is a very, very brief overview of intellectual property. We could all talk all day, and you don't want to hear us do that. Okay. So a couple of times throughout this presentation, you'll see some pictures which I just put in. These actually are real drawings from design patents. From some time ago, as it doesn't, you can't see what it says, but of course the thing on the right is the Coca-Cola bottle. So these are some of the kinds of things that arise with regular clients all the time, and you need to be able to know how to help them. So the first thing where it says your client gets a cease and desist letter for using a photograph on its website, I put that first because there's a lot of that going on. There are many lawyers around the country who are doing nothing but filing these kinds of actions. So you need to watch out for that. Or for instance, if you're a business lawyer and you form a corporation or an LLC for your client, and you've checked Sunbiz and everything is fine, your client can still be sued for trademark infringement. And then they all come and say to us, well, but you know, we checked. Or your client invents something and he asks you for advice and you think, don't worry about it, I'll ask somebody as soon as I get around to it. There are time limits and you need to be careful about that. Or you have an open door policy in your company that says everybody can see everything because our employees are our friends and we have no secrets. Or your client plays the radio in the background to make your customers comfortable. All of that are things that implicate intellectual property issues. So what is it? IP, you know, and we're going to talk about IP, and it's just creations of the mind. And it like I said, it could be your most valuable your client's most valuable asset. But if you just think, I'm not an IP lawyer, so I don't have to know this stuff, you could still get into trouble. And just the breakdown today is that I'm going to talk about copyright, which is a federal matter under Title 17 of the United States Code, and copyrights protect original works of expression. Then after I speak, Matt's going to talk about trademarks, and that's under 15 USC 1051, and as a parallel provision in the Florida statute, Chapter 495. Then Jack's going to talk about patents, which is Title 35 of the United States Code. Like copyrights, it's only federal, and that's about new, useful, and non-obvious inventions. And Jack's going to wrap up with trade secrets, which we've always enforced under the Florida statute, but in the last 5 years, there's now a federal statute as well. Okay, so my turn to talk about copyrights. One of the things that always happens in our business is that people have a lot of information that they think is correct, but it's not. So just to make sure that you don't give your clients bad advice, here are some of the myths that we hear a lot. It's okay to copy as long as I give credit. It's okay to copy if there's no copyright notice. It's okay to copy, and when I say copy, I'm talking about a copyrighted work, if it's for a nonprofit reason or a religious reason or for my church or for a charity. It's okay to, if you pay somebody to make something for you and you give them money, you tell them what you want, and they create it, it does not belong to you unless you make sure that they assign it to you. So just because you pay somebody to make something for you and then you want to enforce it, you better make sure you have those rights. Paraphrasing is still copyright infringement, and downloading from the internet is not okay. So we look at IP, and this isn't just copyright. We look at it from two directions. This is why you need to know. So offensively, you want to help your clients enforce their own rights against others. If they have assets they want to develop and they spent money and time and effort developing them, you want to be able to make sure they're enforceable if somebody rips them off. And then sort of more urgently, you want to make sure that whatever they're doing, they don't get sued for it. So these are just some things that you should know about copyright in general. And once again, they're kind of based on misperceptions that a lot of people have. So there's no law, there's nothing in the copyright statute that says how much of another work you can copy without infringing. You know, when I worked at Reader's Digest and I got there and they said, well, we know it's, you know, you can copy 2 lines or 10% or 5 stanzas of music or whatever. There are no such rules, and that's why every case is different, and that's thankfully why your clients should ask you before they copy something. No copyright notice doesn't mean it's not free to be copied. Just because the author is dead or the corporate owner is no longer in existence does not mean it's okay, because the corporate owner could have assigned the rights, or, you know, those rights could have somehow been transferred in bankruptcy, and a person's copyright rights go to their heirs when they die. So their heirs can enforce those rights. So, you know, so you shouldn't just assume that if the person's dead, it's fine. Giving credit is not enough. It's all about permission. And frankly, in the electronic world, if you give credit and you haven't gotten permission, it just makes it easier for the real copyright owner to find you. You should just assume, even if it's not true, you should just assume that everything before 1925 is in the public domain and it's okay to copy. Anything after that, you should assume is protected. So something from the 1930s or something from the 1940s, that could be protected by copyright still. So just, but 1925 for this year is the cutoff. On the other hand, bear in mind that things that have been, that are from before 1925, but they have been redone, so a new arrangement of an old song can have a new copyright. Just because the work isn't sold for a profit, it's still protectable. You still can't copy it. In general, the statute says that the creator of the work owns the copyright. And that's true unless it's a work for hire or it's been assigned. Copyright is about the owner exercising control over how the work is used and who gets to use it. It's not about credit and it's not about money. And just because you didn't copy word for word doesn't mean it's okay. So copyright's a bundle of rights, and these are the rights that are comprised in the copyright that the copyright owner owns. And that means that the standard one, to reproduce the work, to distribute the work, perform, display, and the right of attribution has to do with works of art, so that if somebody messes around with your artwork, you can take your name off it. Any of these rights that are infringed can lead to a copyright infringement, but you can assign or license any of these rights altogether or separately. These are the kinds of works that qualify for copyright protection. So, you know, I think it's works in the entertainment business, works in the technology area. Computer programs are, for copyright purposes, considered to be literary works. And when I say computer programs, I mean the code. If you write the code, it's just like you wrote a book, and that's protectable by copyright. So in the current lingo, essentially, content is what's copyrightable. But don't get confused, these things are not copyrightable. So a title of a book, a short slogan, those are not protectable by copyright, but they might be trademarks. Ideas, concepts, somebody comes to you and says, I thought up a new way to do something, register it somewhere so nobody else can steal it. That is not the kind of thing that can be protected by copyright. It has to be expression. If you did a lot of work on something and somebody rips off your research, that's too bad, and it may be a violation of academic ethics or scholarly ethics, but it's not copyright infringement. Facts themselves cannot be protected, otherwise how would everybody write biographies of Abraham Lincoln? Scenes of fair simply mean common plot devices that show up if you're writing about or presenting a certain thing. So that came up in you know, so it's really kind of trite plot devices. Anything in the public domain, you know, it may seem like you can't steal things, but if it's in the public domain, you can do whatever you want with it. The United States government is not allowed to own copyrights in things that it creates, but that does not apply to state and local governments. So if Seminole County creates something, or the state of Florida creates something, those things actually can be copyrighted, just not the federal government. Fashion, although they keep trying to get protection for that, is not copyrightable, nor are type styles, although if you want to license fonts from a type company, you still have to do that. And anything that's hasn't been fixed, meaning, you know, some lecture that you attend that's not been recorded, for instance, that's not copyrightable either. So copyright protects only expression, not ideas. It can also protect the way non-copyrightable things are organized together and presented. So if you write a book of poems and you didn't write any of the poems and they're all in the public domain and they're all old poems, but you selected them and organized them into a book, your book is still copyrightable, but the individual poems are still in the public domain. As a matter of infringement, copyright protects only against copying of the copyrightable aspects of a work. So that's distinct from patents and trademarks because it requires that whoever copied had to have actually seen the copyrighted work and copied it. So it's a complete defense if it turns out that you created some work that looks exactly like some copyrighted work just by pure happenstance. Of course, doesn't usually happen, although it comes up in a defense all the time. But if by pure coincidence you create a work that already exists and is copyrighted, that is not, if you can prove that you independently created it, it is not infringement. In order to protect the copyright in a work, you don't have to do anything at all. A copyright exists from the minute the work is fixed in a tangible form of expression. It just automatically comes into play. So what that means is it's not in the public domain. You can't copy somebody's work just because they didn't take any formal action to register it. It is copyrighted, it's just not, and you didn't have to do anything. But if you want to sue anybody, if you want to enforce your rights of copyright, you do have to register. So what is copyright registration? Go to copyright.gov. It's an office of the Library of Congress. And as part of the Library of Congress, which keeps copies of every copyrighted work that's ever been registered, you go to that website and you can see how to register your copyright. It's now done as an electronic matter. The United States is pretty much the only country that requires this kind of formality. The rest of the world doesn't require this, but American works are protected outside the United States by virtue of treaties. This is how to register a copyright. Go to the Copyright Office website, attach a copy of the work to be registered. If it's a software program, you need to read the regs carefully to see how to do that. Fill out the form electronically and pay the money. It's pretty cheap, frankly. It's $45 if you're registering copyright in your own work, $65 if it's anonymous or pseudonymous or a work for hire. And if you want, and what they're telling you here is if you're registering because you have to file a lawsuit and you want to do it quickly, you need to pay an extra $800 to the Copyright Office. Because if you don't do that, it'll take 6 months. Copyright notice used to mean that if you didn't include it on the work and you published the work without it, you dedicated your work to the public domain. The work was no longer protected if you distributed the work without a copyright notice. And I can tell you, we won a case many years ago because somebody wrote a screenplay and distributed it widely without any kind of copyright notice. And then when the movie came out, he said, they stole my work. And we went to trial over it. And the court ultimately ruled, before the jury got it, that because he had distributed his work without a copyright notice, it was no longer copyrighted and he couldn't enforce it. It was never copyrighted and he couldn't enforce it. This changed. It's not true anymore. Copyright notice or not, you can do whatever, you can use it or not, but it's a good idea to put it on everything, whether or not the work is registered. Who owns the copyright in the work? The law says that the creator owns the work, and that means the creator owns the copyright, unless it's a work for hire. A work for hire is something that's prepared by an employee as part of their job. And when I say employee, I mean the kind of employee, and this is not a technical term, the kind of employee, you pay a salary, you take out their taxes, they work on your staff. This law does not apply to independent contractors. Independent contractors, 1099 people, are not considered employees for this purpose, and they own their copyright unless they transfer it to you. Employees, on the other hand, if you're Disney and you hire people to do drawings for Disney, Disney automatically owns it. The employee never owns it. Or you could have somebody sign a work for hire contract, but that has to be in writing and it has to say work for hire for any of these 9 types of work. It only applies to these kinds of work, and it's kind of a strange conglomeration of the kinds of things that can be work for hire. So if the creator owns the work and you want it, the creator must assign it to you in writing. That must be in writing. The creator can't say to you, sure, I'll give it to you. You can do what you want with it. And you say, fine. And everybody understands that the creator said that, because it doesn't count. This is one of those things that has to be in writing. You can also license rights in the work. If one or more authors creates the work, they own it together. And joint ownership is like tenancy by the entireties. Each owner owns 100% of the whole. A derivative work means that it's a work created based on an underlying copyrighted work. That means you need permission from the copyright owner to make it, but the new work, the French translation of a copyrighted work, the French translation that you create is a separately copyrightable work that you can register the copyright in yourself. One thing to remember is that the physical work doesn't give you any rights. So if you buy a painting at the Winter Park Art Show, if you just bought a painting this past weekend at the Winter Park Art Show, and you want to reproduce it in a book, you don't have that right unless you actually bought the copyright. People don't always pay attention, and copyright is only enforceable to the extent anybody bothers to enforce it. And frankly, we all commit copyright infringement every day, but it's important to know the difference. Basically, this is just telling you the copyright lasts beyond when you care about it. So copyright generally lasts for the life of the author plus 70 years after that. If there's no individual author involved, it's 120 years after creation or 95 years from publication. So like I said, just assume that anything, and this is for works created after 1978, anything after 1925, you should assume is still in copyright. Infringement, as I mentioned, is copying of the copyrightable features of the work. Because nobody ever sees somebody copy, or it's very rare, the way you prove it is to show that the defendant had access and the works are substantially similar. That's the indirect way of proving that copying happened. Copy doesn't need to be identical. It just needs to be close enough. And there's no rule as to how close it has to be, unfortunately. So when can you use a copyrighted work without getting permission? That's the fair use concept. This is in the statute, but what the statute says is there are 4 factors to consider. This is section 107 of the copyright law. And it says you have to consider what kind of use is being made. And this is where you do consider if it's nonprofit, educational, a parody. These kinds of things tend towards fair use, but they don't guarantee it. What about the copyrighted work? Is it published or unpublished, fiction or nonfiction? In other words, if you copy from nonfiction, there's going to be stuff that's the same because the facts are not protectable. How much did you take? If you took the whole work, that's worse than if you took just a tiny part of it. On the other hand, if you took a small part of it, but that was the most important part, that could still be infringement. And how does this affect the market for the copyrighted work as a whole? So if what you did means that no one's going to buy the copyrighted work, that's probably not going to be fair use. So with that, I'm going to pass it over to Matt. Thank you much.
All right, thanks, Ava. My name is Matt McKinney, and I'm just going to give you a brief overview of the trademark law, the process of obtaining a trademark, and some common issues that we run into. There should be enough information so when that family member comes asking you how to get a trademark because you're the attorney in the family, this should be enough to get that done and stay out of trouble, hopefully. But what I've got here on the screen is the Coca-Cola trademark, And below that is another trademark that someone attempted to register. And just last week, the Trademark Trial and Appeal Board made a ruling in this registration application, trademark application. So basically, Coca-Cola was upset because I think everyone can see the similarities between the two marks with the C, the script writing, and so forth. But what the applicant was arguing was that the concealed carry trademark was directed to something unrelated to beverages. It's in the field of handguns and so forth. So there's no likelihood of confusion, which is a good argument to make. But the problem was, in this case, Coca-Cola is a famous trademark. So even though Coca-Cola is not in the handgun industry, it gets broader protection. And so the Trademark Trial and Appeal Board found for Coca-Cola on the basis of dilution. So, I mean, this case to me illustrates an issue that could have been avoided if the client came to us and said, hey, I want to register concealed carry, would we advise this client to, move forward with this application, or would there be issues, down the road? And so I think in this case, I would have said, look, we may, even if you could get it, Coca-Cola is going to be upset about it. And they likely would go after you. It's going to create problems. It's going to take away time that you could be spending on your business and growing your business. Do you want to spend your time doing that, or you want to have a trademark fight? So I think it was the right resolution or decision that Coca-Cola does have the rights, and copying the script there with the two C's was enough that it should not be registered. Interesting enough, this applicant had a state trademark registration and brought that up as well, but that was not persuasive to the board. So we'll see. They could appeal to the federal circuit, but at this time, since it just came out last week, but we'll see what happens. I think it is the end of the road for this applicant. When a client comes to you, what makes a good trademark to register? And what we have here is there's kind of a range of different types of trademarks that are given various degrees of protection in the process. So the best marks are these fanciful marks where it's just a made up word like Xerox for copiers, or arbitrary type mark, which is a word that's not related to the actual product or service. So for example, Apple for computers is a arbitrary mark. Most often clients come to us with either the suggestive trademarks, which are fine, or such as Airbus for airplanes is just one example of a suggestive mark. But we get a lot of these descriptive trademarks that people want to register that kind of describe their product. For example, like cold and creamy for ice cream, or best law firm, something like that, where it's descriptive. And it's not that those can't be registered on the supplemental registry, but they typically are not as strong, don't have all the rights as a mark that's registered on the principal register, which is for suggestive trademarks and arbitrary and fanciful trademarks. So if you have a client come to you, try to have, move them up that scale, try to get it more suggestive rather than just a descriptive trademark. So once they've decided on a trademark or a couple potential options, the next step is to see if it's available. We're still back on the other slide, but anyways, you do a trademark search, and what we have is like a lot of clients that say, look, I searched it at the Secretary of State, Florida Secretary of State, it's available, or I already incorporated my company and it was available. Of course, that's not enough. The test is a confusingly similar mark can create a problem. So it's not just the exact mark, but it's also marks that have may sound the same, can prevent you from getting registered, different or the similar pronunciations, Or something else we run into is where the words are pushed together and there's no space between two words versus having a space between them. So you want to search for those types of variations to make sure you don't have an issue down the road. But once it looks clear, like it's not going to have any issues, the next step is the application process. So that's the next slide. And one of the first things to look at is who's the owner. Who's going to be the owner? A lot of times it is easy. You just have a company, start it up, and that's the owner of who's going to own the trademark. But sometimes you have more sophisticated type clients. They've got there's parent companies, sister companies, subsidiary companies, so forth, and you want to make sure you identify the right entity that's going to own the trademark. Sometimes we have clients that they haven't even formed the corporation yet, and if it is filed before the corporation is even created, then the whole application registration can be invalidated down the road. So that's something else you want to keep in mind. And the date of first use is also important. For a service, typically is when they put their website up and they start offering services. That's their date of first use. If it's a product, it has to be the date of a sale. Can't be when they started offering the product. It's actually has to be a legitimate sale. And so the specimens, real quick, is for services typically is a website is good. And for products, it can be a web page as well, as long as there's a shopping cart on the web page. But a lot of times it's just the product packaging or label or something like that will work. Also, sometimes in these applications, you have to disclaim certain words. It could be just a generic term. For example, Ashley Furniture, they have to disclaim the word furniture, so they don't have exclusive rights over that term as well. So when you're going through the process, you may receive a refusal from the trademark office, from the examiner, that you have to overcome. Sometimes they're easy to overcome, maybe amending the description a little bit or something like that. But you may, if you do get the likelihood of confusion type of rejection, then you do have your work cut out for you. And that's what the search up front is trying to avoid, is have that. If your clients sell on Amazon, they want to enroll in the Amazon brand registry. That's a way to shut down counterfeiters. Very easy. It's a great program. Enforcement of rights, we generally go to federal court under the Lanham Act to enforce rights. You can go to state court. You can also sue for the unfair and deceptive trade practices is another option if there's some type of trademark infringement. And I guess lastly is, how to resolve these issues when they come up. So there's a couple different ways that we've dealt with. One is, one party's got to stop using the trademark altogether and change their name. Sometimes that's an option, or sometimes it's the coexistence type of resolution where each party agrees to only use their mark in a certain territory with certain services or goods. But there are some options short of litigation to resolve these issues. So that's kind of it in a nutshell. So Jack, hopefully you have enough time.
Hi, thank you. Again, my name is Jack Abe, and I'm here. I'm just going to give you guys a quick synopsis on the last two types of intellectual property. That is going to be patents and trade secrets, which kind of go hand in hand, in that one is for disclosure and paying a patent, and the trade secret is by its very nature kept secret and confidential. So with that, we'll get into a patent definition. So a lot of people, you'll hear about patents in the common sense, on Shark Tank or the Common Word. People talk about it all the time, but a lot of times they don't actually know what it is. And really, it is just a limited monopoly granted by the federal government, for your invention as it's claimed. And the claim, of course, is something that can get a bit esoteric depending on the discussion, but the claim is within your patent, and it's something that we negotiate with the USPTO, which is the United States Patent and Trademark Office. Another oddity about it is that it is a negative right, which you may recall from law school. So it's not something you can actually practice. It's a right to stop someone else from practicing it. So a lot of folks will run afoul of this because they'll have a patent for their invention and they'll wonder why they're being sued by someone else for patent infringement. Because you may have a technology and improvement on an existing patented technology and you will own exclusively that improvement, but you won't actually own the base technology and therefore you can't make your product. So it could be a bit counterintuitive because you could be holding a patent and you're not able to actually make, use, or sell your invention. Next slide. So there are 3 types of patents generally you need to be aware of. There's the plant patent, which is it's very much kind of a niche practice and somewhat rare, but there's more so of design and utility patents. And the design patent, and I believe that's what we saw in the previous slide, is effectively a protection for the ornamental design of an article of manufacture. It could be a shape of a tool. It's very much, it could be a toy. I think I posted about Star Wars toy on Star Wars Day on my LinkedIn profile. And so you can basically get design patents on a wide variety of little articles. Utility patents, on the other hand, are a little bit more specific. Those are for new and useful processes, machine, article of art, manufacture. There's a lot in there. In reality, if it's man-made and it's under the sun, it's potentially patentable as a utility patent. There are some types of technologies, software, business methods that kind of push the periphery of what is considered proper subject matter. And of course, for those, you probably want to come talk to a experienced patent attorney to get a opinion on whether something can be patented. And of course, then there's the provisional and non-provisional patent applications, which the provisional is a relatively new feature to the patent system in that it's been around for a little over 20 years, but it's effectively a informal patent filing. You might hear about it from your clients because a lot of people do that pro se because there's not a lot of requirements. Patent term, just like with copyrights, it varies depending on what you're dealing with. You get 20 years from the earliest priority date for utility patents, which is a priority date being your filing date, which is part of the reason why filing date can be quite important. For design, there's 15 years from the grant date. And that is, again, that does not take into consideration maintenance fees. And if you're wondering what maintenance fees are, just because you get a patent and it supposedly has a term for 20 years, you still have to pay the federal government maintenance fees at 3.5, 7.5, and 10.5 years from issuance, or the patent prematurely expires. So when you're evaluating patents for acquisition, you do want to make sure that the maintenance fees have been paid. Otherwise, the patent is not valid. So the application process with the USPTO can be a bit involved. So there's 3 stages really you need to be concerned about. There's the preparation and filing stage, which is the first stage, and generally the most costly stage for the process. That usually takes anywhere from 4 weeks to 3 months, depending on the cooperation from the inventor, client. And then once you file it, it will sit with the USPTO for 2 to 3 years. It's unfortunately can be even longer than that, depending on the technology. Software, it's not unusual for software-based technology to take 4 years before the USPTO the USPTO actually picks up your case for active examination, which is the prosecution stage. So at that stage, the examiner will pick up your application and evaluate it for the standards of patentability, which are novelty and non-obviousness. If it meets the standards, you'll get a notice of allowance. More likely, statistically more likely, is that he'll issue an office action with a rejection. And you go back and forth, and then hopefully you get an allowance and an issued patent. And again, because of this, depending on how much prosecution or how much fight you have with the USPTO, the cost is generally front-loaded, but in some cases it's back-loaded also. So it's kind of a dumbbell when it comes to costs. So when it comes to transferability, patents are quite good because they are, even though they're an intangible asset, they're effectively transferable in a whole bunch of ways. You can leverage them as security for loans. They can be sold, they can be acquired, they can be licensed. I mean, there's just, when you go to record these things at the USPTO, which is where you should look for such encumbrances, by the way, there's at least 40 different types of recordings that you can to perform on a patent asset. So that's something to be on the lookout for. When it comes to enforcement, just like with copyrights, enforcement is exclusively within the federal courts and the ITC. although remedies at the ITC are more limited. You can't get money damages. You can only get a importation ban. So pitfalls, and these pitfalls have spikes at the bottom sometimes. So there's what I call inventor owner mayhem. Just like with copyright, you got to be careful about who is the inventor, because by default in the US, the inventors are the owners of the patent. And you want to make sure that's all taken care of and that there's an employment agreement in place and that you've papered up your employees. So there's a transfer, just like with the work for hire regime and copyright. You want to make sure the ownership transfers from the inventor to you, the employer. And if there's not an employment agreement in place, it's unlikely to happen. Apologize, I see a typo here, but there's also disclosures. So disclosures are kind of a pitfall for most patent attorneys, because disclosures can affect the patentability, potential patentability of your invention. So in the US, or actually I should step back. Internationally, if you disclose your invention, you offer it for sale, you put it out before you file your patent application, you're usually, you kind of DOA at that point. You're not going to be able to get a patent. The United States offers a 1-year grace period. And you have 1 year from a disclosure, offer for sale, commercialization. It's extremely broad. Even a secret, confidential offer for sale that doesn't see the light of day is considered a disclosure, and you have 1 year from that point to pursue patent rights, whether that be filing a utility application, a non-provisional application, something. You need to get something on file. So if your clients come to you and they're talking about selling their technology, or perhaps going to a trade show, and again, the reason why trade shows are so a point of emphasis is because people usually bring their newest technology so they can try to sell it and commercialize it. You need to have a filing date beforehand, if at all possible. And if you do go to the trade show without a filing, you need to do so, file a patent application within 1 year. You can go to the next slide. So that brings me to trade secrets, which is the pretty much the opposite of patents. So patent, invariably, it's going to be disclosed. It's going to be published by the United States government. Even if you don't get a patent, it'll eventually be a published application. But a trade secret is effectively the opposite, and that's confidential, and it provides you some type of competitive advantage. Commonly, there's a lot of commonly known ones that are quite famous. KFC's chicken recipe, Coca-Cola, Google search algorithm. These are just things you want to keep that provide you, that are just valuable to your company. And it may not be something as exciting as like a recipe or a search algorithm. It could just be price list. It could be technical know-how or negative know-how. Just effectively anything you would develop internally and you don't want your competitors to know about. So if it gets out in the open, there's enforcement, and that's generally in state courts, as Ava had pointed out, but there's also now a federal regime that you can use. And it varies from state to state, and there's what's called the Uniform Trade Secret Act, which was supposedly going to bring about a more uniform enforcement between states, but still some states have different paradigms, and in fact, some states offer criminal penalties, as California does. Next slide. So pitfalls, again, failure to paper up employees, lack of security protocol, NDA, unenforceable NDAs. These are the things that Ava was talking about earlier, that if you don't treat things as being a secret, a trade secret, and being confidential and being proprietary to your company, the courts aren't going to see that as a trade secret, and you're not going to be able to enforce it subsequently. Which brings me to the most common scenario for trade secrets. It's the rogue former employee. Again, anytime, many people have encountered this. We have a client, their employee leaves, they basically abscond with a lot of confidential and proprietary information, and they set up shop as a direct competitor in the same vicinity. And there's a great famous example, which given our time, I'm not going to go into, but you look into the Waymo, which is the self-driving subdivision of Alphabet Corporation. There's a really interesting case, and it involved misappropriation of trade secrets and all sorts of dirty folks. And, well, I said dirty folks. People were being quite nefarious, in their practices. So if you're interested, you can find a whole barrel load about that case. And I think it's still pending right now. And and I think that's it for me. If you take us to the next slide, and that would be it. Yeah, someone asked about the best practices for protecting software code and rights. Yeah, that's one of those ambiguous things in that it can be protected by either patents or copyrights, and also trade secret. I mean, it's effectively, it's really a case-by-case analysis. Generally, you want to evaluate it before you release, and they're not mutually exclusive. You can get copyright registration. You can also keep it as a trade secret, and also pursue patent protection. It really just depends on the technology, whether it's something that's going to be properly patentable. But generally, copyright's a yes for software. And if the code is going to be, if it's not going to be, you can't reverse engineer it. There is some trade secret portions to it also.
And don't forget to go to the Florida Bar website yourself to enter that. And I believe it'll also be emailed to them.
I'll just thank everybody for sticking with us, and we appreciate it. And thanks, Sherry, for inviting us. And yes, some of us are members of the Seminole County Bar. And so thank you.
Thank you, Ava.
Thank you, everyone.